any violation of civil rights, whether it has to do with money or not. I don't know that. I don't know any distinguishing facts in this case that prevent them from being sued individually under Bivins if there are sufficient facts. But
well, you concede in theory that a constitutional violation of the takings clause could be asserted against an individual government worker in his individual capacity.
Well, I haven't researched that, so I don't know the answer to that specifically. I think we asserted in our brief that there is no vested property right because, pursuant to the complaint, the SEC had the discretion to release funds if, in fact, there are these funds in existence. That discretion alone, under the case law that we cited, suggests that they don't have any property like that. But in answer to your question, I don't know.
Well, there are two questions, I guess. One, is there a property right? And if it's a contingent asset, if you will, subject to distribution for the plaintiffs at the will of the commission. But there's a separate issue as to whether the nature of the relief sought here is such that it can only be asserted against the commissioners in their official capacity.
Well, I don't think there's the government's way of sovereignty in their official capacity in any way.
Well, I understand that, but the issue is there some manner in which these claims could be asserted against the individual defendants in their individual capacities, or is the relief sought by definition relief that could only be sought against them in their official capacity, in which case there'd be no private claim and they'd be entitled to sovereign immunity in their official capacity.
That may be the case. I don't know the answer to that. I do want to... well, I think the court is inclined to be consistent with its tentative as far as the pleading requirements. I think that the plaintiffs have an opportunity to replead, to amend the complaint. We will certainly deal with that issue that the court raised on further briefing. I imagine there will be an additional motion to dismiss in the future. But that being said, clearly these are high-level government officials. They don't deserve to be sued and discovery taken of them unless specific allegations have been made against them. And none have been made in this complaint. I've heard some issues that were addressed during oral argument. I didn't see those in the complaint. But even assuming those are true, there's nothing specific as to these SEC commissioners other than the fact that they somehow have the sole discretion to make every single decision at the SEC. I don't buy that.
Would you agree that it might be easier to assess whether claims can be asserted against the commissioners as individuals if we had a complaint that complied with Iqbal?
That may be true, yes. If in fact they comply with the pleading requirements of Iqbal and they get past qualified immunity, which we also raised, then the court obviously doesn't need to address right now. But if and when the court decides it's been properly pled, then I think qualified immunity should be addressed.
Well, what I'm inclined to do is to dismiss with leave to replead for failure to meet the Rule 8 requirements and to dismiss the claims against them in their official capacity as a matter of sovereign immunity and leave the other issues until we've got a pleading that passes muster.
Agreed. I would only ask that the government have 30 days to respond to the amended complaint.
Thank you. Mr. Hodges?
I certainly recognize, Your Honor, the need to be more specific in complaint, and I appreciate the court's willingness to give us the if that's the court's.
How much time do you want?
45 days with the counsel.
Any objections?
No.
And then 30 days to respond by answer to the motion.
That's fine, Your Honor.
Okay, then we'll modify the tentative accordingly. Thank you very much.
Thank you.
I think we'll take a 10